Hey, my trendies, trendsetters, and my trendy tribe. If it's in the title, you read the title correctly. Maurice Scott is representing Marsau Scott. I guess Marsau may have possibly either run out of funds for Mr. Anderson for those other lawsuits, or maybe Miss Anderson is not one to represent in this type of case. But I have a couple of nuggets for y'all, so we're going to get to it. Hope you enjoy. Okay, I'm taking y'all back to August 2nd, 2023, and I'm going to bring you up until March 4th, 2024. On August 2nd, 2023, it was electronically filed that Builders Mutual Insurance Company filed a complaint against Scholt Industries. Their statement: this is a civil action brought against the defendant, Scholt Industries, Inc., to obtain full and complete relief to redress the breach of contract made by the defendant and to obtain damages for said breach, or alternatively to collect a debt owed to plaintiff by the defendant pursuant to an open account or account stated arising out of a workers' compensation and employer's liability insurance policy, and unpaid premium on that policy plaintiff alleges are owed by the defendant. As we get into this, these dates, in my opinion, coincide when Marsau Scott, aka Scholt Industries, was building up Zen Gardens. And y'all know that there is an open case for Scholt versus Zen Gardens. Please check out my channel for the depositions and everything. It's a lot in there. It's crazy. So he needed workers' compensation insurance for the job that he was supposed to complete for Zen Gardens. That is my opinion. Plaintiff would allege, based on best information and belief, the defendant is primarily engaged in the construction business. Plaintiff is an insurance company which sells insurance in the state of Alabama, including workers' compensation insurance coverage. Alabama law requires any employer who employs 5 or more persons to have workers' compensation insurance covering those employees and any injuries they may suffer that are job-related. Maintaining workers' compensation insurance is mandatory. Therefore, without workers' compensation insurance, defendant could not legally conduct business in Alabama. Employers such as defendant generally purchase workers' compensation insurance through an insurance agent or broker. The agent or broker will try to place the coverage in the voluntary insurance market, but if a policy cannot be obtained, the coverage will be placed with the Alabama Workers' Compensation Assigned Risk Pool, otherwise known as the pool. The plaintiff acts as a servicing carrier for the pool and must follow underwriting guidelines ultimately promulgated by the National Council of Compensation Insurance. On to wit, March 1st, 2020, plaintiff issued a workers' compensation and employer's liability policy to the defendant. The term of the policy was from March 1st, 2020 to November 4th, 2020. The National Council for Compensation Insurance assigned the policy to builders through the assigned risk workers' compensation insurance process. All premium due under the policy was determined pursuant to rules set forth by NCCI's Manuals of Rules, Rates, Rating Plans, and Classifications. The entire policy is quite voluminous and will be made available upon request. The proper rate and premium basis depended upon certain class codes and categories established by NCCI in rules for how payroll is assigned to certain class codes and categories of employees. Classifications were initially assigned based on an estimate of the exposure the defendant would have during the term based on information provided by the defendant in filling out an NCCI workers' compensation application. So Marsau's estimate, or Scholt Industries' estimate, was given to them based on the information they submitted. So that is where their original premium cost was estimated from. If the defendant's payroll was not properly categorized in the classifications, the policy permits builders to audit and assign proper classifications, rates, and premium basis by endorsement to the policy. Premium for each work classification was determined by multiplying a rate times a premium basis. Remuneration is the most common premium basis and includes payroll and all other remuneration paid or payable during the term for the services of the defendant's officers and employees engaged in work covered by the policy. The policy provided that the premium shown on the information/declaration page, schedules, and endorsements was an estimate only. The policy provided that the final premium would be determined at the end of the term by using the actual, not the estimated, premium basis and the proper classifications and rates that lawfully applied to the defendant. According to the policy, if the final premium was more than the premium the defendant paid builders, the defendant was obligated to pay builders the balance of the final premium. Builders was authorized under the terms of the policy to examine and audit all of the defendant's business and financial records related to the policy's premium during the term. The policy provided that information developed by the audit would be used to determine the final actual premium. At the close of the audit, Builders computed the earned premium for that period and sent notice to the named insured on the policy. The defendant's initial estimated premium, calculated prior to Builders being assigned coverage, was $979. So the information that someone from Scholt Industries filled out, I would guess Marsau, they obviously grossly underestimated their coverage, because if they were working on a complex apartment building for Zen Gardens, you know what type of crew you're going to have, and you know what that job entails. So there's no way that from March to November that your premium would actually come out to $979. I don't even think I can insure myself and my husband for $979. I'm putting in my personal input because this is a commentary channel too, but that's just my opinion that should have been a red flag. Not so much for them because they're going to audit, so they're going to see it. That's why they're going to collect their money later. But come on, the person filling out the information and you get that estimate back, that has to scream that that's too low. That's important because what's going to come up in the defendant's answer later, their defense is, y'all, if you know by now the Scotts, you know where this is going. Okay, so let's keep going with the complaint. In accordance with the policy, Builders determined the final and actual premium owing for Builders' policy based upon actual exposure for the audit period of the term and placing the payroll in the correct rating classification. In accordance with the policy and upon close of the audit period, Builders determined the final and actual premium owing for Builders' policy based upon actual exposure was $19,460. A true and accurate copy of the premium adjustment notice dated December 31st, 2020 is attached hereto as Exhibit 3. Based on the foregoing, the defendant was obligated to pay an additional $18,481, the difference between the estimated and actual premium. Builders made demand upon the defendant for such sums due and owing under the policy. The defendant failed to pay the additional $18,481 when due. The defendant breached its contract with Builders by failing to render proper payment as demanded by Builders. Based on the foregoing, the defendant owes Builders $18,481 plus interest at the rate of 10% per annum from January 5th, 2021, which is the date that Builders issued the defendant the first bill for the additional amount of earned premium as a result of the then recent audit activity to the date of judgment. A true and accurate copy of the earned premium statement or statement of account dated September 8th, 2021 is attached hereto as Exhibit 5. Count 1. Plaintiff claims of defendant the principal sum of $18,481 plus interest based on the attached invoice/statement of account as of September 8th, 2022. And count 1 is the verified statement of account. Count 2, open account, and they're claiming the sum again. Count 3, breach of contract. On or after March 1st, 2021, plaintiff and defendant entered into a contract whereby plaintiff was to provide workers' compensation and employers' liability insurance coverage to cover and protect defendant's business operations after being assigned coverage by the NCCI. The defendant agreed to pay the premium for said insurance in accordance with the schedules under the policy. Plaintiff provided workers' compensation and employers' liability insurance for defendant's business operations during the policy period. An audit of defendant's business after the policy period ended determined that the total additional unpaid premium expense for the workers' compensation and employer's liability insurance provided defendant by plaintiff during the policy period was $19,460. After crediting all payments the defendant previously paid, $979, there remained an unpaid balance of $18,481. Defendant has failed and refused to pay plaintiff the total due for this insurance coverage. By failing to pay the premium due, plaintiff defendant has breached the contract between plaintiff and defendant. As a result of the breach of the contract by defendant, plaintiff has suffered damages. Specifically, plaintiff has been deprived of the proper amount of money to which it is entitled for providing workers' compensation and employers' liability insurance to defendant's business operations during the policy period. Those damages amount to $18,481 plus interest as determined by the court until the debt is paid or judgment entered. Wherefore, having fully set forth his complaint, plaintiff demands trial by non-jury and prays for the following: judgment against defendant in the total claim amount, judgment for prejudgment interest as determined by this court, for the cost and disbursements of this action, for such other and further relief as the court may deem just and proper. And again, this was filed in August 2023, over 2 years after Scholt Industries had been notified that it owed this premium amount. So this is the notice that was sent to Scholt Industries. It says, important notice, unless you within 30 days after receipt of this notice dispute the validity of the debt or any portion thereof, the debt will be assumed to be valid by our office. If you notify us in writing within 30 days after receipt of this notice that you dispute the debt in whole or in part, we will obtain verification of the debt or a copy of the judgment against you, and this verification will be mailed to you. Furthermore, upon your written request within 30 days after receipt of this notice, we will provide you with the name and address of the original creditor, if different from the current creditor. This constitutes an attempt to collect the debt, and any information obtained will be used for that purpose. Okay, and this is a copy of the policy. It says the policy period is from March 1st, 2020 to November 4th, 2020. Workers' compensation insurance and employer's liability insurance. And it was for bodily injury by accident, bodily injury by disease, and another bodily injury by disease. So it's each accident, policy limit, and each employee. Number 4 says the premium for this policy will be determined by our manuals of rules, classifications, rates, and rating plans. All required information is subject to verification and change by audit to be made annually. So then there was a notice sent December 31st, 2020 when they ran their audit. It's a premium adjustment notice, and it shows that carpentry construction of residential dwellings not exceeding 3 stories in height is $139,195 in their exposure basis, which basically brought the premium to $19,460 for their total premium. That's the audit adjustment. Okay, and then on January 5th, 2021, as Builders Mutual referenced in their complaint, there was a notice sent, and it says this bill includes an additional amount as a result of recent audit activity for policy number blank, effective March 1st, 2020 to November 4th, 2020. This amount is due and payable upon receipt of this notice. If you have questions concerning this statement, please contact your account manager at the phone number provided on this statement. This statement provides billing information about this specific policy and does not replace your most recent bill. If you dispute any of the amount due on this bill, you must do the following by the due date in order to avoid cancellation procedures from being initiated. Provide to us written documentation outlining and explaining the specific areas of dispute, as well as your estimate of the undisputed amount due and your method of calculation. You must pay the undisputed amount by the due date. Make a written request to the plan administrator for a hearing on the dispute. You may contact us in writing for the name of the plan administrator in your state. Payment must be received by January 25th, 2021 for $18,481. A summons was served. And I almost feel like this is a second time summons, but this is the summons I have most current. A summons was served on February 21st, 2024, and it's noticed to Scholt Industries. It says this answer must be mailed or delivered within 14 days after this summons, and complaint or other document were served on you for judgment by default may be rendered against you for the money or other things demanded in the complaint or other document. So it's issued to the Sheriff's Office saying that they are hereby commanded to serve the summons dated February 16th, 2024. On February 19th, 2024, the person that was authorized says, I certify that I personally delivered a copy of this summons and the complaint or other document to Marsau Scott, registered agent. And affidavit of service says, on the 19th day of February 2024 at 6:36 p.m., I, David, served Scholt Industries, Inc., care of Marsau Scott, registered agent, via personal service by personally delivering the service description as follows. Marsau Scott, registered agent who accepted service with identity confirmed by subject stating their name. I delivered the documents to Marsau Scott, registered agent. With identity confirmed by subject saying yes when named, the individual accepted service with direct delivery. Individual appeared to be a bald, black male, contact 45 to 55 years of age, 5'10" to 6 feet tall, and weighing 180 to 200 pounds with a beard. So then Marsau and his attorney answered the complaint. This is the Defendant, Scholt Industries, Inc. answer to plaintiff's complaint. Comes now the defendant and files defendant's answer to complaint and responds as follows. Defendant denies all material allegations and demands strict proof thereof. Defenses. Plaintiff's complaint fails to state any claim upon which relief may be granted, as there is no valid contract or breach of contract action for amounts claimed. Plaintiff's lack of exposure. Defendant does not owe plaintiff money. Plaintiff's claims for interest and or attorney's fees are barred, as there exists no agreement providing for their recovery. Defendant disputes the validity of this alleged debt. Conditions precedent to filing suit and recovering damage were not met. Plaintiff lacks standing. Failure of consideration. Lack of consideration. Failure to mitigate damages. Plaintiff's failure to prove an open account, including agreement to all purchases and charges added to account at debtor's request. Plaintiff's failure to prove an account stated, including defendant's agreements, the amounts are correct and promised to pay. Misrepresentation. Defendant may have additional defenses and therefore reserve same. Wherefore, having fully answered, defendant prays this honorable court for an order dismissing the instant action with prejudice at plaintiff's costs, attorney's fees, for defendant's costs herein expended, and for such other and further relief as this court deems just and proper in the circumstances. In the defendant's answer, Scholt's answer, they are asking the judge to dismiss the case with prejudice, meaning the plaintiff could not bring it back up again. And as you see here, it is Maurice J. Scott Sr., he said, don't forget the J, that is representing Scholt Industries at this time. The court has issued an order in answer to the complaint and the defendant's answer. So on March 4th, 2024, it says, upon answer of defendant, trial is set Monday, April 1st, 2024 at 1:30 p.m. Done this 4th day of March 2024. So the fools are set to have court on April Fool's Day. How apt. How appropriate. Okay. So there y'all go. All right. Let me know what you think in the comments. Talk to you later. Bye.
This is your man.
Yes,
Look at the screen.
that's mine. And
And
I'm going to stick beside him.
that's what you're going to settle for.
I'm going to stick beside him.
I've been taking my time, taking all of your time, taking